A 71-year-old woman is admitted to the hospital after a fall. She is frightened, her daughter is with her, and within the first 15 minutes, someone hands them both a clipboard and says, "We just need your signatures on a few standard forms before we can get started." They sign. Of course they sign. Who wouldn't? 6 weeks later, a bill arrives for $19,000. Not because anything went medically wrong, not because the care was inappropriate, but because of 4 words buried in the middle of one of those forms. Words that shifted every uncovered cost directly onto her. She is not unusual. This happens every single day. And the people it happens to are not careless people. They are people who simply were not told what they were signing, or what to say instead. By the end of this video, you will know exactly what to say. I am Dr. Hameed Ullah Shaheen, and today I want to give you something practical, something you can write down, save to your phone, and have ready before you or anyone in your family ever walks into a hospital again. Because the medical care inside most hospitals is genuinely good. The doctors are trying to help you. The nurses are working hard. But the administrative and financial systems surrounding that care contain gaps and mechanisms that, unless you know how to navigate them, can cost seniors tens of thousands of dollars, delay critical rehabilitation, and strip away protections that exist specifically to help you. These are not hypothetical risks. They are documented, systematic, and entirely preventable if you know the right questions to ask at the right moments. Let us go through them one by one. This is the one I want to start with because it is the most financially devastating and the most invisible. When you arrive at a hospital and are placed in a bed, you assume you have been admitted. You have a room. You have a care team. You are receiving treatment around the clock. In every practical sense, you are a patient in that hospital. But there is a classification distinction that Medicare makes, one that has nothing to do with how sick you are or how much care you are receiving, that can determine whether your post-hospital rehabilitation is covered or whether you receive a bill for tens of thousands of dollars. It is called observation status. Under observation status, despite lying in a hospital bed and receiving full inpatient-level care, you are classified by Medicare as an outpatient. And Medicare Part A, the part that covers skilled nursing facility and rehabilitation care after a hospital stay, only activates after a formal inpatient admission of at least 3 consecutive days. Observation status days do not count, not one of them. So a patient can spend 5 nights in a hospital under observation status, be discharged to a rehabilitation facility, and receive no Medicare Part A coverage whatsoever for that rehabilitation. The full cost, which frequently runs to $20,000 or more, falls entirely on them. The law does require hospitals to notify Medicare patients of their observation status in writing. This notice is called the MOUN notice, the Medicare Outpatient Observation Notice. It must be delivered within 36 hours of the observation period beginning. Here is what you do the moment you or a family member is placed in a hospital bed. Ask directly, am I being admitted as an inpatient or am I under observation status? If the answer is observation status, follow immediately with, I am requesting that my status be formally reviewed for inpatient admission based on medical necessity. That request is documented. The clinical team must respond to it. In many cases, when a patient or family member explicitly makes this request, the status is reviewed and changed. And if no one has handed you a MOUN notice within 36 hours of arrival, ask for it by name. Have I received my MOUN notice? Those words signal to the hospital that you understand your rights. The entire dynamic of that conversation shifts. Write that question down right now. It may be the most valuable sentence in this video. Trap 2. The form you sign in the first 10 minutes. Within minutes of arriving at any hospital, before you have seen a doctor, before you understand what care you need, often while you are frightened and in pain, someone hands you a stack of papers and asks for your signature. Consent forms, privacy notices, insurance authorizations. Standard things, they tell you. Routine. And buried within that stack, sometimes as a standalone page, sometimes folded into a longer document, is a clause that can have significant financial consequences. It is a blanket financial responsibility agreement. In plain language, it says that you accept personal financial responsibility for any costs not covered by your insurance. In most circumstances, insurance companies negotiate rates with hospitals. What you owe as a patient is the negotiated amount, substantially less than the hospital's listed price. But when you sign a blanket financial responsibility agreement without qualification, you may be giving the hospital the legal basis to bill you at their full, undiscounted rates for anything not covered, bypassing the negotiated protections entirely. This is called balance billing, and it can represent thousands of dollars in charges that your insurer would otherwise have reduced on your behalf. Here is what to do instead. You do not refuse to sign. Refusing to sign may genuinely delay your care, and that is not the goal. Instead, before you sign, write this phrase directly next to your signature, in pen, right there at the desk. Signing only for authorized insurance benefits, not accepting personal liability for balance billing. It is legal. You can do it in front of the intake staff. It documents your intent clearly, and it protects you from having that signature interpreted later as a waiver of your insurance negotiation rights. Take a photograph of that sentence on your phone right now. When you arrive at a hospital, you will not be in a state to remember it from memory. Have it ready. Trap 3. The discharge that happens too soon. Hospitals operate under significant pressure from insurance companies to discharge patients as quickly as clinically justifiable. The result is that discharge conversations sometimes happen earlier than patients and families are fully prepared for, and sometimes before the patient is genuinely ready. A doctor comes in and says you are doing well enough to go home, and because it is a doctor saying it, and because everyone is tired and the conversation is brief, most patients agree, gather their things, and leave. 3 days later, they fall, or the wound is not healing, or they are back in the emergency department, which costs far more than the additional hospital days would have. What most seniors have never been told is that Medicare patients have a formal right to appeal a discharge they believe is premature. This right exists. It is free to exercise, and it provides real protection while the appeal is being reviewed. Here is how it works. If you or your family does not feel the discharge is appropriate, you request an expedited appeal through your beneficiary and family-centered care quality improvement organization, commonly called a BFCC-QIO. You can find yours through Medicare.gov. Once that appeal is filed, the hospital cannot legally discharge you while the review is being processed. The words you say to your care team are simple. I do not feel medically ready for discharge, and I am requesting an expedited QIO appeal. You do not need to argue. You do not need a medical degree. You need those words said clearly to the nurse or the case manager. From that point, the process has a formal structure that protects you. Write that sentence down alongside the others. The medication switch you were never told about. Hospital pharmacies operate from something called a formulary, an approved list of medications the facility stocks and dispenses. That formulary may not include the specific brand, the specific generic, or the specific formulation of every medication you have been taking at home. When a medication you depend on is not available in the hospital formulary, the standard practice is substitution, replacing it with a different version that the pharmacy has in stock. This can happen without a clear conversation with you, sometimes without a clear conversation with your admitting physician. For adults over 65, sudden medication substitutions carry real risks. Blood pressure management, heart rhythm medications, thyroid treatments, these are calibrated over time to your specific physiology. A substitution is not always clinically equivalent in its effect on your particular body, and the hospital pharmacy charges its own rates for substituted medications, which are frequently higher than what you pay at your regular pharmacy. The protection here requires preparation before you ever need it. Maintain a written medication list, not the name alone, but the exact brand name, the exact dosage, and the exact timing for every medication you take regularly. Keep a copy in your wallet or your phone. When you or a family member is admitted, hand that list directly to the admitting physician and say, "Please do not substitute or alter any of my maintenance medications without an explicit clinical review and my written consent." That sentence places the responsibility where it belongs, on the clinical team to flag any intended substitution to you before it happens, not after. Trap 5. The out-of-network specialist you never chose. You did your preparation. You confirmed your hospital is in-network with your Medicare Advantage plan or your insurance. You felt confident going in. Then, weeks after the procedure, an envelope arrives from a physician you do not recognize. A radiologist, an anesthesiologist, a consulting specialist who briefly reviewed your case. Someone your insurance considers out of network, even though they walked into a room in the building you verified. This happens because hospitals and the physicians who work within them are often contracted separately. The facility may be in-network, while individual physicians, even those regularly working in that facility, operate under their own separate network agreements with different insurance plans. Federal legislation called the No Surprises Act was specifically designed to address this. It gives patients the right to receive care from in-network providers without unexpected out-of-network billing. And it gives you a specific phrase you can use to invoke that protection at the point of admission. The moment you arrive at any hospital, before any procedure, before any specialist is brought in, say to the admission staff or the billing department, "I am invoking my rights under the No Surprises Act. I consent only to treatment by in-network providers." That statement is documented. If the hospital subsequently brings in an out-of-network provider after you have made that declaration, the financial responsibility for the out-of-network cost is legally theirs, not yours. This is a right you already have. Most people never use it because no one tells them it exists. Your 5 sentences. Let me give you something concrete before this video ends. 5 sentences. That is your hospital protection protocol. Write them down now, on paper, in your phone, wherever you will actually find them. 1. Am I being admitted as an inpatient, or am I under observation status? Ask this the moment you or a family member is placed in a hospital bed. 2. I am requesting that my status be formally reviewed for inpatient admission based on medical necessity. Say this if the answer to sentence 1 is observation status. 3. I am invoking my rights under the No Surprises Act. I consent only to treatment by in-network providers. Say this at admission, before any procedure or specialist visit. 4. Please do not substitute or alter any of my maintenance medications without an explicit clinical review and my written consent. Say this when handing your medication list to the admitting physician. 5. Write this next to your signature on any financial form. Signing only for authorized insurance benefits, not accepting personal liability for balance billing. And one more to keep ready. I do not feel medically ready for discharge, and I am requesting an expedited QIO appeal. Use this if a discharge is suggested before you or your family believes it is appropriate. 6 sentences total. Every one of them invokes a protection that already exists, that was designed specifically to protect you, and that most patients never use because nobody ever told them to. I want to close with something that goes beyond finances. The patients I worry about most are not the ones who ask too many questions. They are the ones who stay quiet because they assume the system is taking care of them, that the forms are routine, that the discharge recommendation is final, that the bill that arrives is simply what they owe. That assumption, that passivity, is where preventable harm lives. Understanding your rights does not make you a difficult patient. It makes you an informed one. It makes you someone who can have a productive, specific conversation with a care team rather than a frightened, confused one. And in my experience, clinical teams respond better to informed patients because those conversations are clearer, the concerns are more specific, and the outcomes are better for everyone. The woman I described at the beginning of this video, the one who signed the clipboard and received a $19,000 bill, was not naive. She was not careless. She was simply unprepared for a system she had every right to navigate confidently. You are now prepared. Share this video with someone in your family who is over 60 or who manages the healthcare of someone over 60. These protections are only useful if you know to invoke them before you need them, not after. Leave a comment below. Tell me which of these 5 traps you were most unaware of before watching. I read every comment. I am Dr. Hameed Ullah Shaheen. Stay informed, stay protected.